Hello, this is attorney Darrion Holloway with Shane Smith Law. Welcome back to another Know Your Rights segment, and today we'll be discussing the presumption of innocence. If you're charged with a criminal offense, you are presumed innocent until proven guilty. This presumption helps us with the criminal justice system, ensures fair trials, and makes sure nobody is wrongfully convicted without enough evidence. This presumption of innocence creates a burden of proof upon the prosecution or the state to prove their case beyond a reasonable doubt. Now, what's important is this burden never shifts to the defense. The defense is presumed innocent until proven guilty, and they don't have to say a word. In fact, in most trials, criminal defendants opt to not say anything and remain silent. Now, this burden and this presumption of innocence lies on the table of the prosecution. It starts at the beginning of the trial, it goes to the middle of the trial, and it continues to stay with the prosecution at the end of the trial. This burden never shifts to the defense. Now, the presumption of innocence is only overcome if the state or the prosecution proves every element of the crime alleged beyond a reasonable doubt. Now, beyond a reasonable doubt, it's not all doubt, but it's sufficient evidence that the trier of fact, the judge or the jury, feels confident in finding that person guilty. So if you're faced with a criminal charge and you're going to trial, know that you are presumed innocent until proven guilty. If you have any questions, feel free to give us a call at 980-999-9999. And as always, in pain, call Shane.
In pain, so I call Shane. 980-999-9999. In pain, call Shane.